Hi everyone, and welcome to Any News Australia, where we look to provide a balanced view on some of the challenges that business is facing, small business is facing in this country, covering business law and the economy. My guest today is Greg Dunstan from Dunstan Legal and Motor Vale, who will be summarising the recent Supreme Court case, Kassam Henry versus Hazzard. And so welcome, Greg.
Thank you, Anthony.
So just before we start, I just want to confirm for everyone that you're not associated with any of the parties of the case, and you've just been observing as a third party. You sat in on the live stream virtually, so you're going to provide your legal summary of what you witnessed over the last 4 days.
That's right, Anthony. I've been watching like everybody else online, and just taking notes as things went, because I'm vitally interested in this case, probably for all the reasons that everybody else is interested in it.
Yeah, I'll hand it over to you, and let's go.
Okay, thanks, Anthony. Well, I'm not even going to try and condense 4 days into 1 hour. I might be able to condense 1 day into 1 hour, possibly a bit more, maybe 2 days. But the purpose of this is just because I am a lawyer that was an observer of this case, that I thought it might be useful for people who are not lawyers to have the benefit of me summarising and recounting what happened, just in case you got lost during the time that you were following it. There were parts of the case that were particularly technical, and it would have been very easy to get lost if you were watching it and didn't have any legal training. And because of the interest and the public interest of this case, I thought that it might be helpful for all of you to have an explanation in as simple terms as possible of what went on. Now, today I won't be making comment about the rights or wrongs of, or the strengths or weaknesses of the respective cases, because the case is still in the course of being decided. Once the case is decided and the judge hands down his judgment, then I'd be prepared to comment on the judgment and whether it's likely to be appealed, or whether there's likely to be any possible grounds of appeal. But those matters will be decided by the lawyers acting for the plaintiffs. The lawyers acting for the plaintiffs are preeminent lawyers. One is a senior counsel located in Sydney, and the other is a Queen's Counsel located in Victoria. And both of them presented the cases adequately, and so did their juniors. A junior is a barrister who is not raised to the rank of a QC or a senior counsel, but they can be quite senior lawyers as well. So the word junior is a bit of a misdescription, because they're normally quite experienced lawyers also. What I thought I'd do first was that there was an interlocutory proceeding before Justice Kavanagh, and an interlocutory proceeding is a proceeding that's not the actual main hearing. And the interlocutory proceeding was about the fact that the minister had resisted answering a notice to produce the crisis cabinet papers. The reasons why the minister wanted the crisis cabinet the plaintiffs wanted the crisis cabinet papers was because they wanted to establish that the minister had failed to take into account relevant considerations, and that he had just taken a one-size-fits-all approach and had only considered the reasons for making the orders, but not the reasons against making the orders. Now, if they were successful in getting their hands on these documents, it could have worked against them, because the documents might have shown that he had taken into account reasons for not making the orders. but they were prepared to take that risk because they wanted the court to be informed with as much information as the court could, so that the court could come to a just decision. The reason why the minister resisted it was because the crisis cabinet papers regarded as being subject to cabinet confidentiality. A little bit like if you go to your lawyer and you tell your lawyer things, you want to be free to openly discuss all the pros and cons of your case and the weaknesses and the strengths. And you don't want your lawyer to have to, or anyone to be able to compel your lawyer to disclose what you talked about, so that you can get a fulsome legal advice from your lawyer. Well, the similar thing applies with cabinet. Cabinet has privilege because it's normally regarded beneficial to the public interest, because it enables cabinet to thrash out an issue, airing agreements and disagreements without having to air their dirty linen in public. And then they come to a consensus, or even if they don't, they come to a decision, and they speak as one. And it's the law takes the view that if the cabinet thought that everything that they said was going to become public, that might stifle a lively discussion within the cabinet room. And so it's regarded that it's not in the public interest, because it would detract from the proper governance of the state, because half-baked decisions would be made where people weren't free to openly express their opinions. So that was why they resisted it. And the court accepted that this immunity from having to produce documents was not absolute. But the High Court had said that even though it's not absolute, the High Court found it difficult to imagine any civil case where the circumstances would be so exceptional that they would depart from the normal rule of cabinet confidentiality. Now, the High Court said that there may be exception in a criminal case, but this obviously isn't a criminal case. So it was up to the plaintiffs to show that the public interest for the proper administration of justice was so exceptional that it trumped the public policy of cabinet immunity. And they had to show that it was so crucial to their case that their case couldn't even be heard without it. So the court also said that it was even more difficult to allow the exception where the exception was being sought in the middle of a current crisis. They said if the crisis had passed and there was not likely to be any further cabinet discussion on the point, that it would be a slightly lower bar that would have to be hurdled to reach that threshold for the exemption. But they said that where there was a current crisis going on and where further crisis cabinet meetings were likely to be required, that the court had to take into account the fact that the crisis cabinet discussions might be stifled in going forward if they felt that there was a risk that everything that they said might become public. So that was the very high bar that the plaintiffs had to jump before they were successful in that application. The problem for the plaintiffs in the actual hearing of the case, of course, would be that the plaintiffs would then, if they couldn't get their hands on these papers, they'd have to be able to rely upon an inference that because no documents were produced, that no documents existed, and that therefore the minister had not taken into account relevant considerations. The further problem for the plaintiffs with that was that the law is that if you don't produce something because you have a legal right not to produce it, such as, for example, a communication between you and your lawyer, if you refuse to produce a privileged document between you and your lawyer, the law is that the court can't infer any adverse interpretation of that refusal against you. And so likewise with the Cabinet, because the Cabinet have immunity and because they have the legal right to exercise that right of immunity, the plaintiffs would be deprived of any inference that might arise by those documents not having been produced. So it was a tough task for them. So they're embarking on a very challenging fight where they weren't holding a very strong hand. The exceptional circumstances that they argued were that, which were to outweigh this long-standing principle of cabinet confidentiality, were as follows: that the vaccines had been made compulsory in the order for anybody who wished to be employed that were the subject of the order. That the vaccines, once injected, can never be removed from the person's blood. That never in the history of Australia has such a serious order been made under delegated authority. And by delegated authority, I mean not by an act of Parliament passed by Parliament. It was being done by a minister by virtue of a delegated authority given to him under the Health Act. And what they were saying was that for this to be done, it had never been done without Parliament itself debating and discussing and passing a law about it. The next point that they said that was an exceptional circumstance was that the order affected the right of an individual to their bodily autonomy, to the right to work, to the right to earn a living from that work, and to the right of privacy and to the right of freedom of movement, which they said were unprecedented. And also that in determining whether the decision of the minister was reasonable, the court would need to know the pros and the cons taken into account by the minister. And the plaintiff said that the public and the court had heard all about the pros as to why the vaccine should be taken, but that heard nothing about the cons as to why the vaccine shouldn't be taken, such as a disclosure of any risks that were involved. I think the closest that risks were ever addressed were statements like that the side effects are extremely rare. The minister disputed that the public health orders were mandatory, remembering that the first exceptional circumstance that was submitted was that the vaccines were compulsory. He disputed that the public health orders were mandatory, and he said that they were merely incentives, because the individual still had the right not to give the vaccine and to give up work. The plaintiffs contended that was no choice at all. Now, the decision that the judge came to in that interlocutory proceeding was that, firstly, the documents before the crisis cabinet very well could have a legitimate forensic purpose which might assist the plaintiff in their case. However, he said to the plaintiffs that in their submissions, which he'd read, they had already said in their submissions that the existing evidence already established that the minister did not take into account countervailing reasons for making the orders. And therefore, because they had already expressed that the evidence was, I suppose, sufficient, or to establish that fact, that he took it, therefore, that it was not crucial to their case that the documents be produced. And finally, he said that the plaintiffs have not established that the circumstances are so exceptional that the public interest immunity of Cabinet should not be maintained. So the end result of that is that the plaintiffs didn't get the benefit of knowing precisely what the minister had before him when he made the decision, and what factors he did or did not take into account. So I see you've appeared on the screen, Anthony. So do you have any questions at this point?
Yeah, there's some questions that have come through from the audience that I thought might be fitting. So it's maybe, I think you might have answered it, but why does the Cabinet have this immunity? And there was another question relating to that. It hasn't been overturned in a previous case that they've got this confidentiality or immunity.
Well, there was a case that they were all talking about called the Commonwealth versus the Northern Land Council, but that case established that the right to immunity wasn't absolute. But in this particular case, the judge didn't feel that the circumstances were exceptional enough to fall within the exception in that case.
Sure. Okay.
And as to your question as to why the Cabinet confidentiality exists, it's pretty much for the similar reasons to why communications between a lawyer and their client are privileged. Because for a person to get proper legal advice, the lawyer needs to know the case, warts and all, and without the client being at risk of what they say being later subpoenaed and put into evidence against them, almost like preventing people from making self-incriminating statements. But with the Cabinet, it's so that it's for the good governance of the state and in the federal parliament, the country, so that robust discussions can be had within the Cabinet room. Like, I'm pretty sure that the New South Wales Cabinet room hasn't been in total unanimity about this. And I've got strong suspicions that, and I don't know, but I've got strong suspicions that Dominic Perrottet, the new Premier, dissented from time to time. But he may not have dissented and expressed his view if he thought that the government might be attacked because what he was saying in disagreement could later be made public by a subpoena or a notice to produce. And so therefore it might stifle people who wanted to argue against something.
Sure, of course. All right, I'll let you continue.
The case itself was not heard by Justice Kavanagh, who heard the interlocutory case. It was heard by Justice Beach Jones, who's the Chief Judge in the Common Law Division. And there were two groups of plaintiffs. One was represented by Mr. King, SC, who's a former Liberal member for the seat of Wentworth, prior to Malcolm Turnbull. And one was represented by Mr. Clark QC, who is located in Melbourne. And his junior counsel, who's a fairly experienced lawyer, was a Dr. Harkis. And the court ruled that the evidence in one of these cases would be the evidence in the other as well. So there was a benefit to the plaintiffs there, because what one plaintiff missed might be picked up in the evidence that the other plaintiff filed. Now, one of the things that makes it difficult in a commentary and explanation of this case is that most of the evidence in this case was written and in the form of affidavits or in the form of expert reports. So as the public, we don't actually get to see those. So we don't really know what the full evidence in the case was. So we're left to glean from what was said in submissions as to at least parts of what might be in those affidavits and in those reports. There were a number of lay witnesses who filed evidence. I think there are about 7 for the plaintiffs. And one presumes that they gave evidence about the effect of the public health orders upon them. There were a number of experts' reports filed for the plaintiffs. One was a Dr. Kassam, who was a research scientist, and he was responding to Dr. McCartney's affidavit in relation to the spread and transmissibility of the virus after vaccination. Now, Dr. McCartney was the main witness for the minister. So he was responding to her evidence about transmissibility and after vaccination. And Mr. King said that his evidence was also about the consequences for a person infected after the vaccination. The minister didn't seek to cross-examine him, so his evidence was admitted without challenge. There was also an affidavit filed by Professor Brody. Professor Brody is an Australian doctor or professor, and he's located in Sydney. But no indication was given as to what his evidence was directed toward. I have some knowledge of Professor Brody, and I would suspect that it was directed toward treatment of COVID-19 and the available treatments that are available. There was also an expert report and evidence given for the plaintiffs by Dr. McCulloch. Many of you watching will have already known of Dr. McCulloch. He's an American doctor, and his evidence was directed to the availability of treatments as an alternative to vaccination. Now, why that evidence was important was because the plaintiffs, as part of their case, were saying that the minister had failed to consider alternatives. The next expert that the plaintiffs filed evidence from was a Professor Cameron. Professor Cameron gave evidence which was casting doubt on the PCR testing, and therefore, because of doubts that he cast upon the PCR testing, which I imagine was to the effect that it overstated the amount of COVID-19 cases, his evidence was therefore that the response to the virus was an overreaction. The court, though, ruled that this evidence didn't go to the issues in this particular case, and his evidence was not admitted into evidence. The court was not satisfied that it went to the question of whether the orders were reasonable. The next evidence or expert that the plaintiffs called was a Dr. Tyson. His evidence went to the fact that he was a treating practitioner who had treated 6,000 COVID cases. And his evidence was that only 4 of those 6,000 had died, and that of those 4, all of them had comorbidities. So this once again would go to the argument by the plaintiffs as to the failure to consider alternatives to a unidirectional vaccination program. The next expert that the plaintiffs presented was a Professor Brighthope, and his evidence was directed towards nutritional medication. I presume things like vitamin C, vitamin D and vitamin C and zinc and all of those nutritional immunity boosters. And the next and final expert that the experts called was Dr. Parks. And Dr. Parks attached to her report numerous studies which challenged the evidence of Dr. McCartney, who was giving evidence on behalf of the minister. So on behalf of the minister, there was Professor McCartney. Professor McCartney was a vaccinologist and also an ATAGI member, ex officio member, but she was not part of the COVID-19 task force. The second expert called by the minister was Dr. Gale, who was the deputy health officer of New South Wales Health, and she attached to her evidence, I think, a report in August by the Doherty Institute. And the third witness was a Miss Boyd, rather, who was the assistant to the cabinet. So they were the witnesses that the plaintiff called. Do you have any questions at this point, Anthony?
No, not really at this stage. I think there's some comments. People are just discussing different aspects, but like we mentioned before the show, that you're not able to answer anything about the case in general, just the information that you're providing. So nothing really that we can ask at this stage on what you've said so far.
Yes, while the case is going on, I don't wish to engage in commentary about it. And the purpose of this is just to give everybody an overview and to help everybody to understand what's going on. So we're now in day one of the hearing, and I thought it might be useful just to go through some of the questions that Mr. King asked Dr. McCartney as the witness for the minister. But you can see from all of the experts that the plaintiff called that they've gone to exhaustive measures to try and support and present this case in a very short space of time. And I think we should all have a lot of admiration for the effort that's been put in. So the first question to Dr. McCartney was whether dexamethasone, which is was a steroid for inflammatory responses, could be used with COVID-19. And the answer was that it's not approved for COVID-19. The next question was, hasn't it been used on numerous occasions? And her answer was that she was not involved in the COVID-19 team. She was then asked had she read Professor Brighthope on the nutritional treatments of zinc, vitamin D and vitamin C. Her answer was that there was no robust evidence to support that. The next question was, are not the nutritional treatments safe and effective? Her answer was that she didn't agree that there was no evidence on or about their use. The next question was, have you personally investigated the efficacy of zinc, vitamin D and vitamin C? The answer she gave was no. The next question was the letter to the health minister by Mr. Nikolic, which set out an alternative treatments, ever referred to you for you to consider? Now, many of you will have seen that letter by Mr. Nikolic because it's posted on his website. And that letter is quite exhaustive and comprehensive. And within it, it does contain an exhortation for the minister to consider alternative treatments. And Dr. McCartney was being asked here whether she'd ever been given a copy of it. She said no, she hadn't. The next question was, have you ever been involved in any studies on the safety and efficacy of hydroxychloroquine?
Hydroxychloroquine, I think is.
So the answer to that was no, that she had prescribed ivermectin for parasites, but she had apprised herself of the relevant information about those treatments. Now, she was asked whether she'd ever been involved in studies for the numerous listed treatments, and there was a multiple list of drugs that were put forward as possible treatments, and she said no, she hadn't. She was then asked, are you familiar with the Steinberg research in 2021 on stools which demonstrates that a vaccinated person may transmit COVID-19 and that a different strain may emerge which may cause damage to the microbiome? Her answer was that it's not typical to see changes, and she disagrees that it damages the microbiome. She also said that mutation requires hundreds of thousands of infections for mutation to occur. She was then asked, have you ever done genetic sequencing in microbiome research? To which she said no. Then she was presented with a study by Gert van der Bos in August-September 2021 in 40 to 49-year-olds that showed that per 100,000 people, 1,151.2 vaccinated were infected, and 787.1 unvaccinated were infected. Her attention was also brought to the fact that Israel are up to their third and for some their fourth booster shot, and also that the WHO state that within 4 weeks of infection, antibodies develop an immune response which is robust and effective. And that's talking about natural immunity. There were uncertainties were also put to her that the Atagi report stated that there are a number of uncertainties with the vaccines, such as with the immune compromised and pregnant women, and that these matters are subject to ongoing trials, and that the TGA approval was a provisional approval. Her answer was that she had reviewed all of the available evidence, and from observing her, it seemed that she had read, or she said that she'd read hundreds of papers. She said that her opinion was that there was no harm to the fetus from a pregnant mother being injected, although she had done no research on that herself. So those were the questions that were asked by Mr. King. She was then further cross-examined by Mr. Clark SC. But before I go on to his questions, are there any points that you want to raise, Anthony?
So one of the questions I had, and also been come through in the comments, is if she testified that she wasn't part of the COVID team, then why was her testimony allowed? What do you feel about that?
Well, because her CV was sufficiently qualified, showed her sufficiently qualified to reach the threshold of what constitutes an expert witness.
Sure.
And once you cross that threshold, then it's up to the court how much weight they give. For example, one of the plaintiff's witnesses, Dr. Clark, was challenged in relation to Dr. Clark's expertise and whether Dr. Clark had crossed the threshold. And his evidence was eventually admitted, but the judge said it's admitted, but I reserve the decision as to how much weight to give to it. And it was primarily admitted, just going forward a little, because much of the cross-examination of Dr. McCartney was based on studies that were attached to Dr. Clark's report. So the judge said, well, if for no other reason, then the cross-examination of McCartney wouldn't make any sense without those reports being in evidence, then I will allow Dr. Clark's report into evidence. But just because he's allowed it into evidence doesn't mean that he's going to give it as much weight as other experts. And likewise
Sure.
with this expert. Okay. So then our Victorian senior counsel, Mr. Clark, and when I say our, I don't mean mine, I mean the plaintiffs, he then continued to ask questions. Dr. McCartney, by the way, I'm not sure if I've said this, but she wasn't involved in treating COVID-19. She was I think she was at the works in the paediatric section of the Children's Hospital, and they have a COVID-19 section, but she doesn't work in that section and she doesn't treat COVID-19 patients. And that was one of the things that the plaintiff's lawyers said was why less weight should be given to what was said in her evidence and in her report. So Mr. Clark, his first question was, he asked her to agree that the virus was continuing to mutate. Her answer was, yes, but subtly. It's rare that it leads to different qualities. The next question Mr. Clark asked was, as at June 2021, there were no other variants than Delta in circulation, were there? And her answer was that Delta is the dominant variant throughout the world. His question was that Delta has changed the landscape and is more transmissible. Her answer was that it's 2 times more transmissible. Now, I'll put a caveat there because I'm not sure that I transcribed that correctly, because my understanding was that it was much more transmissible than 2 times. So there's a slight caveat over that answer. I might have written down 2 times incorrectly, but that's what I've written down. The next question was lack of scientific certainty on the vaccine efficacy and transmissibility among the vaccinated. Her answer was that vaccines protect against symptoms and serious illness. And for 65%, the vaccine prevents infections. So therefore, if the infection is prevented, those 65% can't transmit at all. The next question was, isn't it true that the viral loads in the nose of the vaccinated are the same as those in the unvaccinated? Her answer was, well, this is only at one particular point in time. I'm not sure what the inference from that was, but that was her answer. The next question was, there are conflicting studies on the effectiveness of the vaccine, aren't there? She said yes, but they all trend in the same direction despite those variations. The next question was, directed towards a report known as the Collin and Powell report that Professor McCartney had relied upon. And Mr. Clark made the point that this report that you've relied upon states that the vaccinated and the unvaccinated have a similar peak viral load. Her answer was, since my report, there have been studies that the vaccine is 50 to 70% protection against the Delta. She also said that Collin and Powell did not say that the vaccines were not protective against infection, and that it did not look at the question of transmission. She said, as at the September 2021, there were no studies available on transmission by the vaccinated. There were for Alpha, but not for the Delta strain. The next question was directed to a statement by Dr. Park, where Dr. Park had said that SARS-CoV-2 is poised to acquire complete resistance to wild-type spike proteins. And the answer was by Dr. McCartney that the report is not peer-reviewed and that she did not necessarily agree. Next question was that with the Pfizer vaccine, there are often breakthrough cases observed. Her answer was that she did not agree, that there were dozens of studies that show strong antibodies and maintenance of strong cross-reactivity. Dr. Clark then asked, Mr. Clark then asked, have you read the reports that in relation to the effectiveness of the vaccines, that natural immunity is 13 times more effective than the vaccine? Her answer was yes, but that is a preprint. Now, just as an aside here, a preprint is a study before it's peer-reviewed. Well, at least that's my understanding. So she was saying here that it hadn't been peer-reviewed. Mr. Clark said to her in the next question, but the Powell report, which you rely upon, is a preprint too. Her answer was yes. The next question was, have you read the Kona report published in the New England Journal of Medicine about the experience in the San Diego Health, which showed that 130 of 227 workers were fully vaccinated, and of them, 109 of the fully vaccinated were infected, and 80 of the unvaccinated were infected. Also, have you considered that in Israel, which is vaccinated, has more case numbers than the Palestinian territory? Her answer was, you cannot just work on cases. You have to work out the cases of vaccinated relative to the whole of the vaccinated population, and likewise for the unvaccinated, so that you arrive at a percentage of the vaccinated people who have become infected and a percentage of the unvaccinated population who have become infected. The next question was that the vaccine is waning after 5 to 6 months, whereas natural immunity lasts for 17 years. Her answer was that the vaccine effectiveness is tracking similarly to natural immunity, and the virus has not been with us for 17 years to know if that is true. I can give you a sneak preview into later evidence in the case, that the 17 years comes from studies in 2003 in relation to the SARS-CoV-1 virus. And it was later on in the case, it emerges that there are studies that show that natural immunity for the SARS-CoV-1 virus was effective for 17 years. And so I think what Mr. Clark is doing here is he's extrapolating that to the likely length of time for for natural immunity in relation to the SARS-CoV-2 generated virus. The next question was, are you aware of the Barnsdale, Massachusetts study, which is peer reviewed, where there were 469 cases and there was 69% coverage of the Barnsdale locality, and that 74% of that population were fully vaccinated? The answer was there was potential reporting bias in the report, and it again couldn't specify the relative rate of infection amongst the vaccinated and the unvaccinated. The next question was, are you aware of a study by 37 scientists in Vietnam in relation to the transmissibility by the vaccinated published in The Lancet? In breakthrough infections, the viral loads were 250 times that in the strains prior to Delta. The answer was that she agreed. The next question was, there are no cases of breakthrough cases in naturally immune persons. The answer was that she disagreed. The next question was, here it is. The reports in relation to the 2003 SARS-CoV-1 showed that natural immunity lasted 17 years. Her answer was that she would want to study the data for SARS-CoV-2 over many years before coming to the same conclusion. The next question was, do you agree that there is a lack of scientific certainty about vaccine effectiveness? Her answer was no. The next question and final question was, do you agree that the Delta is less deadly? And she said, no, it's similar. So, Anthony, we're 3/4 of an hour. Do you want me to proceed with a summary of the last two witnesses for the Minister?
There's some questions being raised, and I know you can't speak to how strong or weak that testimony was regarding the case, but there's a couple of things that sound a little bit contradictory to me, which was, if the viruses do mutate, then they do so in a subtle way. And then also in the media, we hear that the Delta strain is more contagious and more deadly and so forth as well. But she seems to confirm that it's got a similar mortality rate to the original virus as well. But so anyway, very interesting.
She wasn't saying that the mortality rate. What she actually said was, do you agree that the Delta strain is less deadly? And by that, they were talking about previous strains, less deadly than previous strains. And she said, no, its deadliness is similar to previous strains. So that was her opinion.
Okay, sure. Okay.
Now, I can say that the plaintiff's lawyers strongly attacked the weight that should be given to Dr. McCartney's evidence. And naturally, the counsel for the Minister, Mr. Kirk, Senior Counsel, said that her credentials were impeccable and beyond challenge. So it remains for the judge to decide.
Sure. Did it get raised about some of the funding that she might have received and whether that brings a conflict of interest to her testimony?
Yes, that was raised. I haven't put it in here. It was raised, but just really in passing. There was nothing put to her that because of that she might be untruthful. And Mr. Kirk, for the Minister, said that it's quite common for health agencies to receive the benefit of funding, and that that the fact that funding had been received in relation to I don't think she personally had received funding. From recollection, it was organisations that she was involved with. I could be wrong about that.
Sure.
But Mr. Kirk for the minister said that the fact that they had received funding really went nowhere because it was such a common practice.
Okay, sure. Yep. There's probably 10 minutes left. Do you want to continue with some of the other?
Yeah, well, I can finish day one. Remembering that there's 4 days, I can finish day one in the next 10 minutes.
Okay, go ahead. That's great.
I'll just continue on. The next witness for the minister that was cross-examined was a Dr. Gale. Dr. Gale is not a vaccinologist or an immunologist. Her qualification is as a public health physician. Dr. Gale said that her evidence was not based upon her being involved in any studies herself, and that her evidence was based upon, quote unquote, the body of evidence. This body of evidence seemed to be primarily the material that was referred to in the Doherty report of August 2021 and the modelling in that report. That report was later commented upon by Mr. Clark SC because he made the comment that the Doherty report was actually, and the modelling in that report was based upon assumptions. I might get to what assumptions are in a moment. The point was made to her, here it is. The point was made to her that the Doherty modelling was based upon assumptions and that assumptions are not established facts. Now, experts in court cases are often asked to rely upon assumptions, and the lawyers ask them to rely upon those assumptions because those assumptions reflect the facts that the lawyers will be attempting to establish during the course of the court case. But because the court case hasn't occurred at the time that the expert report is prepared, the expert can only make assumptions that those facts are true facts. And what remains thereafter is that the lawyers then have to prove those assumptions to be correct, as a matter of fact, during the court hearing, so that the expert opinion that they're trying to rely upon doesn't falter on the basis that assumptions were made that were later proven to be inaccurate or incorrect. Now, Dr. Gale was not aware of any contrary body of evidence to the body of evidence upon which she relied. And based upon all of the above, she stated that Delta is more transmissible with a shorter incubation period. Elderly people are more susceptible. Vaccines prevent infection and transmission. And vaccines are used in concert with screening, which is testing, and PPE, protective equipment. It was accepted that the vaccinated can be infected. But no less than the unvaccinated. She was not aware of the material about whether the vaccines were less effective against Delta, and she relied upon the Doherty Institute's extensive review of the source studies. Now, her evidence was attacked even more stridently by the lawyers representing the plaintiffs in their latest submissions at the end of the case. So the next witness was a Katherine Boyd, who was the Cabinet Secretary since April 2019. But Anthony, that's the end of day one. So perhaps that's a convenient place to end today's session.
Yeah, for sure. I mean, there's some people in the audience that are asking. I mean, everyone's sort of really eager to get an update from the last day and where this is all going. I know I've had conversations with you over the days of you watching through. We really appreciate the time you've taken to be sitting in on the 4 days, and also the time after the case finished presenting to summarize this for us. Look, I prefer, rather than jumping ahead, to sort of do it on a day-by-day basis. And so are you happy to tune in tomorrow at about the same time, Greg, and we'll continue with day 2?
Yes, we can go to chapter 2 tomorrow.
Yeah, chapter 2 tomorrow, great. And we'll talk about when we might do the others, or how much we might cover in tomorrow's session as well.
Yes, well, tomorrow will include details concerning the cross-examination of Katherine Boyd, the Cabinet Secretary, the cross-examination of the Acting Secretary for Immunisation and Communicable Diseases employed by the Commonwealth, and then submissions by the Senior Counsel for both plaintiff groups, and those are probably going to be possibly more interesting than today, because there they really get into the meat of their criticisms of the public health orders.
Yeah, okay.
But hopefully this gives an introduction, sort of a preliminary understanding of how the legal system works, and how it's based on evidence, and how things unfolded up to day 2.
Yeah, thank you very much. And I guess the intention behind this was, I know some people, I mean, even myself included, was able to jump on for a little bit over the 4 days, but wasn't able to watch the whole thing. And then some people also watched the full days, but having a sort of a legal professional sort of summarizing for us, I think, has been very valuable. And once again, we understand you can't comment to the outcomes or the strength or weaknesses of the different testimonies, but I think you've covered a lot of information for people to consider already. And tune in tomorrow, everyone, for day 2. And thank you all, almost 190 people that watched live today, and thank you for all the comments and interactions there. Please share this video as well, and subscribe to tomorrow and other videos. Next week on Wednesday, we'll be speaking with Alex Cooney, the Coffs Harbour ex-police officer, about his letter to the police commissioner, and other things like that. So stay tuned for all of those. And thank you again, Greg, for your time today. And we'll talk again tomorrow.
My pleasure, Anthony.
Great. Thanks again. Thanks, everyone.